going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. I've got a good one. We are in Battleground, Washington, in front of Judge Wheeler, and we have a defendant who just decides to do what he wants to do while he's out on bond. Yeah, doesn't end up too well for him. It's a bold strategy. All right, anyways, let's just get into it. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Good afternoon, Your Honor. I'm just looking to see, is Jeff Harlan present in the courtroom?
Yes,
No, he's there on Zoom, I see.
yes.
And are you ready to proceed on that matter, Mr. Green?
I am, Your Honor. I think we have to deal with a couple issues. I wasn't present at the last hearing. I was in a deposition and Mr. Bogar handled it, but I do have an update for the court.
Yeah, go ahead when you're ready.
Okay, well, as far as the case is concerned, Your Honor, I believe we're still waiting on toxicology results that we necessarily need based on the charge to be able to effectively resolve the case. So as far as that's concerned, to set the matter out, I guess another 6 to 8 weeks with the speedy trial waiver effective the return to court date.
I think we'll probably, before we reset it, I think I would like to talk about the release violations.
Sure.
I'm hoping maybe you can help me understand, because it looks like your client, Mr. Harlan, misses UA. Mr. Harlan misses UAs almost every month. And I know that most folks are only called for a UA once a month. So before this court, we have a missed UA on the 17th of March, the 18th of February, the 23rd of January, the 18th of December, the 25th of November, and then he was just entered onto the UA condition in November. So he's missed UAs every month. I've never quite seen that. I'm not sure how a person would achieve that. So what can you tell me about that?
I think, and again, I wasn't present at the last court date, but I did talk with Mr. Bogar, and Mr. Bogar talked with Mr. Harlan and Ms. Carmy, and then in fact reached out to supervised release. And the issue, according to, and I can bring Mr. Bogar on if you want to hear it directly from him, but he made contact with supervised release. The supervised release, who he spoke with, Gerardo, said he's called. I don't know why they haven't explained how necessarily to get onto the color line, because when Mr. Bogar talked to Mr. Harlan, he wasn't aware of what he needed to do. And so he's calling supervised release. Apparently they're not passing on the message or passing on the information for exactly what he needs to do to be, I guess, I expect, calling in for the color line. And so that is the update that I have with respect to the missed UAs. He lives in Longview, so that's no excuse or reason for missing them. But our position, I believe 2 weeks ago, was that this wasn't a knowing violation because it hadn't been sufficiently explained to him what he needs to do. And notwithstanding the fact that he's maintaining contact, they haven't taken any steps to make sure he knows what he's supposed to be doing to comply with the court's order.
I have a different update from the
Yeah,
case
I'm not going with that. Go ahead.
So that same day after our last hearing, because Mr. Bogar had asked that question, and frankly, I didn't know the specific answer on how he would be notified, but they indicated that if the defendant has questions, they can either call to watch monitoring to verify or utilize their online portal. They are given both options upon intake. And if we think back to how this case started, there was an initial pretrial violation because he didn't sign up for services. We didn't have to go down the road of a pretrial violation hearing because he did then sign up for pretrial services. That would be the intake where those instructions would have been given. So, you know, the city's perspective is pretty clear. He hasn't done any UA testing. He has a controlled substance and a DUI pending. I don't know what else to share with the court other than this does seem like a very willful failure to get a UA.
Yeah, I disagree. I mean, I think there's been a number of violations that Mr. Harlan has been aware of. The question is, what is the court going to do at this stage? Because if it was an alcohol case, I'd put a scram monitor around his ankle at this point, but it's a drug case and he doesn't choose to do UAs. So I am really tipping on the tipping point of just taking him into custody because I mean, this is unacceptable. I don't know if he's done a single UA during the time of his release. And I am baffled that, yeah, I don't really have much more to say. So unless you have other information for me, Mr. Green, I don't know what else the court can do at this stage.
Your Honor, if I could I just briefly have a breakout room with Mr. Harlan so I can discuss this with him and we can come back and effectively deal with it?
Yep. So Mr. Harlan, you're going to get an invitation to a breakout room here momentarily. Please accept that invitation so you can speak in private to your attorney, Mr. Green.
Okay.
All right, so you guys understand what's going on. Yeah, dude's just not doing his UA. Sorry, my phone just went off. I usually have it on silent, distracted me for a second. Yeah, 6 months or about 6 months. He hasn't done a thing. And yeah, just testing once a month. You have to do it once a month. Once a month. Even for the people that are trying to hide a drug or alcohol problem can hide it for a couple days a month. Man, you can't even do it once a month? Yeah. You're in trouble, man. And Judge Wheeler is a judge that gives so many chances. A ridiculous amount of chances. And he will say, this is your last chance, like 3 or 4 times before he puts you in jail. He's fed up with this guy. All right, and it's not over. There's something else that comes to the court's attention here in a second.
All right. Mr. Green, are you ready again on Mr. Harlan?
I am, Your Honor. Thank you. I appreciate the opportunity to do the breakout room.
Okay.
So, Your Honor, I think we have things squared away. There's a couple of logistical issues. Our proposal to the court is this, because obviously we want to make sure there's no issues moving forward. Mr. Harlan had his court date 2 weeks ago. Again, just to refresh the court's recollection, Mr. Bogar covered as I was in an all-day deposition. There was some question about the requirements, and Mr. Bogar was going to follow up on that. So the case was continued to today. Mr. Harlan is out of the state this week on a job that was pre-scheduled, and everything was good to go before the case got continued to today. So
hold on, let me understand. When you say pre-scheduled, he had the permission, because the court would usually sign a waiver of a UA requirement.
No. Yeah, I'm not saying he was permitted to miss a requirement. That's not what I'm getting at all. I'm just saying I think when his work was scheduled for him to be out of town today, that was with the understanding that his last court date would have been 2 weeks ago from today. That's all I'm saying.
Okay, so
our proposal is,
what do you want me to do?
So I've given him the information on how to contact 2Watch. He's going to be in contact with them as soon as this hearing's over. I've also advised, and he's agreed to do, since he's out of the state, he would at his own expense go and get an independent drug test today, that he would sign a release for to be released directly to my office and to the court or to Ms. Carmy if that is something that the court wants to do. I don't think there are going to be any issues moving forward. He understands that he cannot miss any future UAs, and he's indicated to me he has nothing to hide as far as substance abuse, and that's why he would be able to get that test today, so to demonstrate some modicum of compliance. And so I would be asking that you reassign. The other issue is, since he's out of state, if the court was going to take him into custody, that creates obviously a logistical issue. And if the court was going to do some sort of sanction, I would ask that the sanction be imposed when he's back from work. He gets back on the 21st of this month.
So Mr. Green, is an officer of the court, you have a client, Mr. Harlan, who has release conditions. Mr. Harlan was originally assigned those conditions back in September. Mr. Harlan's conditions were reassigned in November. Mr. Harlan then missed conditions in the month of November, December, January, February, and March. And now you're informing the court that Mr. Harlan has departed the state without any kind of release of any of the UA conditions and is unavailable to the court for the next 2 weeks on his own choosing with counsel. So that's not an acceptable outcome. The only belief that a judicial officer should have when someone has missed 6 UAs is that person is continuing to use substances. I have no belief that Mr. Harlan cannot navigate the release conditions after this amount of time and this amount of chances. So he is getting taken into custody to return to Clark County, Washington, to be booked into custody no later than the 16th of April. So I'm not going to make him come back right now, but no, we're not doing this anymore. This is ridiculous, Mr. Harlan. This is not acceptable. This is a violation of a number of the release conditions the court have set for you. This is not within the realm of acceptable behavior for you to leave the state without getting leave of the court, without getting leave of your conditions. You are to report to the Clark County Jail no later than 5 p.m. on the 16th of April. I'm going to set a review date for the very next day, which is the 17th of April, 2025. If you are in custody, that'll be at 8:30 in the morning. If you do end up posting bail and are out of custody, that'll be at 1:30 in the afternoon. I am imposing bail in this case in the amount of $7,000. I have no other way to explain to you, sir, that this case has to be a more compelling thing on your calendar than just something that you're choosing not to do. If you don't understand, you have a learned attorney who's been assigned to your case initially. You have an extremely qualified attorney who's assigned to your case now. There should be no way you can't navigate a simple process 6 months in. And if I sound a little perturbed, I am a little perturbed. To be very honest with you. This is not acceptable.
I apologize.
Release conditions on Mr. Harlan's case are to be raised to the intensive level of pretrial release. Mr. Harlan, you are not to depart the state for any reason without leave of the court to where you're not able to be available for UA testing.
Okay.
Release conditions should be to violate no laws, appear at all mandatory court dates, notify the court of any change of address or phone number, no consumption or possession of alcohol, non-prescribed drugs or controlled substances. UAs are reassigned. I don't have any other release condition I can impose. You're on intensive pretrial release with Clark County pretrial release. You are to report to custody 4/16 of 25, no later than 5 p.m. You are to bring picture ID. We will get your attorney the document that you will have to bring to check into the Clark County Jail. Bail in the amount of $7,000 is imposed on that case.
You are scheduled for court the very next day. If bail is posted, that court appearance will be at 1:30 in the afternoon. If you are still in custody, it'll be at 8:30 in the morning. Do you have any questions whatsoever regarding the conditions the court has set?
Yes, Your Honor. I have a return flight on the 21st of April. I'm not sure how I can get that switched to the 16th.
That's
Jeff,
not,
Would it be
that's not the
possible?
court's consideration, sir. You made the choices that you made. I am giving you latitude to reschedule your flight. You are back in Clark County on the 16th of April. Do you understand?
Yes, sir. Thank you.
Jeff, as soon as we're done, I need you to call my office, okay?
Okay.
All right.
Mr. Harlan, we're going to be mailing you some documents, sir, to the address the court has on file for you. Are you still getting your mail on Bodine? All right, we'll send the documents there. If there's nothing further, you can log out.
Thank you, Your Honor.
Thank you.
All right, that's it. Yep, this guy absolutely FAFO'd, and the judge still gave him a little leeway. He has a week to turn himself in, so yeah, asking for the extra week. I mean, you can always ask, but yeah, judge isn't happy with him. No. So yeah, he gets to turn himself in. So I will be watching this court on the 17th. We'll see if he's in jail or if he's free. $7,000. That's not a little bit of money. But if sounds like he's working and he's traveling for work, he might have it. We'll see. We'll see what happens on the 17th. All right, that's it. Hopefully you guys enjoyed the video. I liked the video, so if I liked the video, you should hit the like button. Is that how it works? Let's just go that way. All right, you guys are awesome. Thank you so much for watching. Until next time, bye.